Well, good evening, everyone. I want to call the Civil Rights Advisory Group meeting to order. I want to thank everybody for being here tonight. I would like to take the time for us to go around the room and introduce ourselves, if you don't mind. James, you want to start?
Yes, I'm James Rector. I'm with the Northwest Arkansas Center for Equality.
I'm Sue Addison. I'm a landlord here in Fayetteville.
I'm Ann Morney. I'm the general counsel for the different Lindsay entities, Lindsay Management, Lindsay Associates, Lindsay Construction, blah, blah.
I'm Laura Hampton. I'm a disabled person.
Maria Baeza Hicks. I'm just a citizen.
I'm Danielle Wood. I work at the University of Arkansas, and I'm also a member of the Air National Guard.
I'm Ann Shelley. I'm the director of the Northwest Arkansas Rape Crisis Center.
Tony Hughes, the CPA with Hogan Taylor.
Caitlin Bartow, representative of the transgender community.
Mark Martin, Martin Law Firm here in Fayetteville.
I'm Kim Coates. I'm a lawyer practicing labor and employment law.
I'm Lowell Grisham, pastor, live in the historical district.
Jim Huffman, pastor of Christ Church on the south side of town.
Bill Bradley from Washington Regional.
Curtis Smith, pastor of St. James Baptist Church here in Fayetteville.
Lee Folson, I'm a sustainability planner with the city of Fayetteville.
Lindsley Smith, communication director for the city of Fayetteville, and I'm staffing this meeting, so if there's something you need, let me know.
Okay. And Mayor, I'm Kit Williams, Fayetteville City Attorney.
And I'm Mayor Jordan. I want to thank everybody for being here tonight. I want to start off by the reason that I have called this group together. I do appreciate, I see Mr. Clark out there, I do appreciate the letter he sent last week. We had been in some discussions about possibly doing an advisory group for that, but I thought that was a very fine letter, so thank you very much for that, Mr. Clark. So what I call this group together for, and I want to just lay out some rules what this group is about tonight. Now, this ordinance has been passed. That's over. That's done. Now it comes to the point where we implement the ordinance. And what I've asked this group to do is to give me advice on how to best implement the ordinance, Civil Rights Administrator ordinance. And I welcome your advice and whatever pitfalls that you think there might be. But as far as debating the ordinance, that has been done. And we're not taking any public comment tonight. We had 13 and a half hours of public comment. I have heard a lot of public comment on this particular ordinance. So what I'm needing from this group tonight is input on how we implement it. Whether you think it's a good ordinance or a bad ordinance is not the question here. This has been passed by the legislative branch of this government. The ordinance is done. Now it's time to administer it. And I welcome your input. I think the first order, there's going to be some presentation. I've asked Lee Folson from our planning department to give us a presentation on what 4 cities are doing. 2 of them from Iowa, 1 of them from Missouri, and the other one, Bloomington, Indiana. So he will be discussing cities that's our size that has university, higher education entities in them and how they have best implemented this particular ordinance. But I know a lot of the questions that has been around town is who I'm going to pick as the Civil Rights Administrator. I'm sure you're all curious about that. Well, I'm going to answer that question tonight. And the person I've chosen is extremely talented and someone I have worked with for a number of years. Doesn't work for me, but he works with me. And he's been a great partner for me and a great counselor and a great friend. And I could not think of anyone that would be better qualified or suited to be the first Civil Rights Administrator than our own City Attorney, Kit Williams, and I'd like to introduce him.
Okay, thank you, Mayor. And I was somewhat reluctant to step forward here. Obviously, a pretty contentious matter, but I think my decision to agree to the mayor's request for a 1-year period, not a permanent appointment, I think will be made relatively clear through Leaf's presentation, so maybe he should give his presentation, and then I have something else. You know, I have a little handout to give to you to explain that I will in fact be willing to do this, but I think that Lee's presentation studying the other cities that have this kind of ordinance will shed some light on why they felt like, the mayor felt like he needed a lawyer to do this job, at least initially.
Thank you, Kit. Now, Leaf's going to give a presentation, and one of the things that I've been looking at is not only the civil rights administrator, but also a commission. And so he's going to address some of the more successful cities. And Leaf, go ahead and
Sure.
presentation.
The mayor asked me to find 4 cities that were approximately the size of Fayetteville, that had a large university presence, and that had passed human rights ordinances and had implemented those. And so for the 4 peer cities that matched really well with that criteria, I chose Bloomington, Indiana, home of University of Indiana, or Indiana University IU, Columbia, Missouri, the home of University of Missouri, Ames, Iowa, University of Iowa, and Iowa City, Iowa, Iowa State. The populations of these cities are similar to Fayetteville. Fayetteville is about 76,000 people. They range from 62,000 in Ames, Iowa to 115,000 in Columbia, Missouri. Looking at the elements that all these cities had in common in regards to their human rights or their civil rights legislation, they all had similar procedural actions for how they administer the process of receiving inquiries, investigating complaints, determining cause, facilitating mediation or conciliation, and ultimately prosecution if needed. So the elements that those peer cities all share is all 4 of those cities use a human rights commission for hearing registered complaints. These boards all meet on a once-a-month basis. They investigate claims of discrimination in the areas of housing, employment, public accommodations. Some have also merged departments to look at investigation of discrimination in regards to, for instance, ADA complaints. They're all internally staffed by a city employee. They've all developed procedures for registering and investigating and mediating complaints. They all keep records of the number and type of complaints that are lodged in a fiscal year, and they typically summarize those in an annual report that they release to the public. It states how many inquiries they had, how many investigations, how many mediations, or how the complaints were ultimately dealt with. They typically cover discriminatory actions related to age, race, ethnicity, national origin, marital status, sex, religious affiliation, sexual orientation, gender, familial status, disability, and retaliation. All of them participate in public education and outreach efforts in the community. And in telephone conversations with the peer cities, they indicate that their staff ranges from 1 to 4 people that administer these programs. Because some of the programs have combined their ADA compliance, they'll have investigators that may go out to determine ADA compliance. And so that's why you may end up with more people on staff than other cities. Telephone conversations with the staff of these cities also indicate that there can be a significant amount of time and resources that is spent investigating claims that ultimately may not be deemed to have merit or may need to go to a higher level of government, a state or federal agency. Typically, the city is kind of the place where all those complaints come in, and the administrator kind of figures out whether that's a local issue or that's an issue for another body. Some of those peer cities have partnered with the law departments at their local university for interns and mediators. The staff for the human rights commissions are varied, but for the most part, they commonly have an administrator that is an attorney. This is also confirmed with discussions that I had with the Human Rights Campaign staff, who said that that's the most common way to do it. It's not the only way to do it, but typically somebody with a legal background is the staff for the Human Rights Commission. Bloomington, Indiana also reviews affirmative action plans for contractors who do work for the city. So, you know, you may have certain different tasks that are assigned to the commission. Some elements of our ordinance here in Fayetteville that are different from some of the peer cities that are analyzed is our ordinance specifically addresses areas of employment, housing, and public accommodation. We don't address education or ADA complaints in our ordinance. Some of those peer cities have very strong state human rights ordinances. Like, for example, the state of Iowa has a very strong ordinance at the state level. And so some of the complaints are actually kicked up to that commission. Our ordinance includes protections for gender expression, which was not found in the 4 peer cities evaluated. They all had protections for gender identity. Gender expression is something that the Human Rights Campaign is really, is kind of a newer thing, and what that means is gender expression refers to the way in which individuals manifest either masculinity or femininity, expressed through their appearance, speech, behavior, movements, and other factors for which the individual wishes to be understood as either masculine or feminine. The other term that we have in our ordinance that was not found in the 4 peer cities that I looked at is socioeconomic background. And I think Kit will probably address that. So for the committee, if you go to the next page, you have a spreadsheet. This spreadsheet lists the 4 cities, the population, kind of the setting, how they set up their commissions. Typically, commissions in these 4 cities range from a minimum of 6 members to 9 members. Again, the administrator is typically an attorney, not in all cases, but typically an attorney. They've all developed a procedure, criteria, how they investigate the reports. Again, they all do an annual report that lists the number of complaints and how they were processed and what the end result was. The next page, this page, is just an example that we put together of a brochure. Actually, in our ordinance, it talks about having a form that employers would put on the premises, in the break room or what have you, talking about the process. And so this is kind of something that we put together as a draft. It's not totally filled out in terms of who that would go to. The next page, 2 pages in your booklet, is a draft authorization release form. This would be the form that the complainant would fill out when they came and talked to the civil rights administrator. That was based off of forms that have been utilized by other cities. The next pages are actually our ordinance, so anybody that's unfamiliar with how our ordinance is actually set up, those are those pages. And then the tabs, starting with tab 1, is the city of Bloomington. This is their annual report. Bloomington does a really good job in their annual report of listing all of the breakdown of the complaints that came in any given year, and then how those were resolved. And they also, in Bloomington, they keep a running log of the telephone conversations or the personal conversations that the administrator has with people that come in. So they know how many inquiries come into the system on an annual basis. And they put this all out in an annual report. Bloomington does a really good job of public outreach and getting out in the community. They budget some money that they spend every year to do that kind of work. Tab number 2 is the City of Columbia, Missouri, another annual report listing the number of complaints they had and how those complaints were resolved. The third tab is Ames, Iowa. And this is kind of an example of the brochure they use in terms of what the complaint process is, what the jurisdiction and the applicable discriminatory actions are. Their release form, which we based our draft form off of Ames, Iowa. And then the fourth tab is Iowa City, Iowa, their brochure and their annual report. So there are a lot of common elements found in the human rights commissions from these 4 cities. Most notably, they all utilize a commission. They all have staff at the city that takes in the inquiries and determines probable cause and where that complaint should go. And they all have a process for working through a mediation process to resolve the complaint.
All right, thank you, Lee. Kent, would you like to give your report?
Yeah, I don't have too much to report. I did agree to the mayor appointing me and with the right to delegate to my assistant city attorney when I might be gone, which I do sometimes take vacations, not as much as I like. Let me hand you a few copies of this for the members. And let's see, let's go that direction too. The statute itself, the ordinance itself says the mayor will designate who the civil rights administrator is. And initially, I was assuming the mayor would designate someone on his staff. I think I even responded to one of our aldermen saying I did not. Do we need more of this? Did I not hand out enough of these?
I got an extra one.
Here, hand some more down around. I felt like it would be possibly a problem because the city prosecutor is the one that actually has enforcement powers if mediation cannot be resolved. Then the city prosecutor works for me. So I felt like it might appear that there would be undue influence by me over the city prosecutor's decision whether or not to prosecute. However, we simply don't have that many lawyers working for the city. Most of them work in my department. And so I've done some things within this in order to try to preserve some autonomy for the city prosecutors. I'm really not going to be an investigator. What I envision happening is I will receive a phone call or somebody will come into my office and they'll have a complaint. And I will listen to them. I'll probably take a few notes about some things. I don't think I'll have a form nearly as complex as you see here. I don't want to know certain information like their date of birth because I don't want to have to try to protect that and protect their identity. But I will certainly get some information, especially contact information from them, and information about obviously what they felt was a problem. And initially, if it appears to be something that this ordinance would cover and would not be better handled by the EEOC or something else like that, if it's a true employment problem that they would have much better access to being compensated for, they shouldn't come to us because no complainant will ever get a penny through our system. That's not the way it is. It's not one person against another person. They come in. If we can't come to a resolution, it has to go to the city prosecutor. It is the city of Fayetteville against the person who is doing the discrimination. It's not the person who thinks that they were the victim. And so there will never be any compensation for any victim that comes through our system. However, if they can sue under the Civil Rights Act, or they can sue under the state Civil Rights Act, then you can get restitution, you can get compensation, you can get attorney's fees. So if a situation exists where it is a violation of the federal Civil Rights Act or the state Civil Rights Act, they shouldn't be coming to me. If they have an ADA compliance problem, they shouldn't be coming to the Civil Rights Administrator. We're only there for the limited purposes that the City Council approved this, and that's because the federal law doesn't cover every category where there can be discrimination, and some of those categories are covered by this particular ordinance. And so those are the cases that I would probably really listen to and hear. Now, when someone comes in, after I get their basic information from them, what would I do? Well, I'm going to call up the business or the person who the complainant feels has wronged them, has discriminated against them. And I'm going to ask them for their side of the story. I was a deputy prosecuting attorney for 5.5 years. I've heard many times, I'd hear the complainant come in and talk about how terrible, what this crime was committed against them, and I talked with the other side, and guess what? It wasn't always true. In fact, one time, I agreed to arrest everybody in the room. I had two sides that had both come in and complained. I thought, well, we can arrest you, everybody, if that's what you want, but I'm not going to pick and choose who I'm arresting. And so I know there's two sides to many stories, most stories, I would say, and so I will want to listen to both sides of the story. I view this job as primarily someone who mediates. That's what the ordinance says. He wants to conciliate these two sides. If there has been apparent discrimination going on, then why can't we get it stopped? Once the person realizes that their actions are probably in violation of the law that was passed by the City Council, I think that most people will say, well, I didn't realize that, and maybe let me do something different. Let me stop that. So I think that most of what my work will be trying to bring the two sides together so that there is a resolution, and that's it. Won't always work that way. Could be that there will be one side or the other that just believes that there's no resolution possible. If that's true, then my finding would be that one of two things. I would either say that I'm referring this case, the complainant, to the city prosecutor's office for him to go file, or her, go file an affidavit with the city prosecutor, and then it'll totally be up to the city prosecutor to take it from there and do whatever the city prosecutor believes is proper in that particular case. I can also say I'm not going to refer you to the city prosecutor because I don't think you have a case, but I'm not stopping you from going to the city prosecutor. You come to me, you've told me what you believe, and if you want to go to the city prosecutor, you certainly can. And I'm not going to tell the city prosecutor he can't do anything. My report to the city prosecutor is either I recommended that they go to you or I didn't. There's going to be another part of the city policy, and for the city attorney's department, is that the city prosecutor will not be able to subpoena me for any prosecution he might want to do in this case. I don't want to be an investigator that will be acting as an advocate one way or the other in this particular kind of case, so that the city prosecutor, if he wants to go forward, is going to have to make his case without any testimony from me. I'm primarily a mediator. And I don't know if you all had much experience in mediation, but when you go into a mediation, everybody signs confidential agreements. You can't ever use anything that's said in mediation in the trial that's going on. Now, I'm not going to have anything like that, but I am going to say that I will approach the people and say, I will not be a witness against you. If you want to tell me your side, which I hope you do, let's sit down and talk about it. If it doesn't work out, it goes to the prosecutor cannot subpoena me. Now, well, I can say that because I'm the prosecutor's boss, and that's our official city policy. I'm not city attorney policy, not city policy. But That way, I don't have to feel like I ever have to give Miranda warnings to anybody, because you don't get very far in mediation if the first thing you say is everything you say can be used against you. I don't want that. I'm striving in this particular case, while I am the civil rights administrator, to resolve issues, not to make them bigger. So that's what I will do, and the mayor's agreed to only hold me to a 1-year period of time. And partly that is because right now we don't have another person in the city that really has mediation training that you get as a lawyer. Other lawyers we have in the city are really too busy to do this. But I think I'm too busy to do it too, but I'm going to do it. I do think that we can get someone with good common sense and send them to training for mediation and arbitration and conciliation. Give them a little bit of experience in civil rights law, so they can direct people if they have a different kind of problem. They know where they should go. And I think within a year we can have someone else appointed by the mayor who will be able to take over and be the city rights administrator. I just didn't think we had anybody right now. I encouraged the mayor to find somebody, and he looked diligently, but it came down to it just didn't appear that we were ready to go. And so I've offered to do this pretty reluctantly, because I'm not so stupid as I don't realize I'm stepping in the middle of a whirlwind, but that's all right. That's part of taking this job, Mayor. It just is doing that. So that's what my plan is. I think the mayor will appoint me, and in my absence, I would designate the assistant city attorney to handle the cases when I'm on vacation or sick or something like that. But I will take this. I don't envision, if you look at the reports you've seen there, you're probably not going to get a good report like that out of me. I'm not planning on making such an in-depth report. I'm not planning on being an investigator or somebody. If the person who has been complained against doesn't want to talk to me, the only thing I can do at that point is just refer to the city prosecutor, because if they don't want to say anything to me, they don't have to. I'm not going to force anybody to talk to me. And if they don't want to do that, if they'd rather go into and just speak with the city prosecutor, they certainly can do that. So I don't plan to be a big investigator. I don't plan to have a whole bunch of other reports and other things for them to fill out. There's one other thing. The mayor may, and he's talked about it, and I think it's something he's still considering, he may appoint a citizen commission that might be able to be useful for me at times. If it's a complex case, a difficult to resolve case, but both sides still want to try to work on a resolution, then that would be the kind of case I would take to this citizen commission. And I hope it would be a commission hopefully filled with people that help others resolve disputes. Because we got to remember, both the civil rights administrator and commission have no real power. All the power really is with the city prosecutor. We can't force anybody to do anything. All we can do is talk to the sides and see if we can reach some sort of agreement. So if it's a very difficult case, I think at that point in time, if the mayor wants to have a commission to help, that would be the kind of case I would take to them. If it's an open and shut case where someone doesn't have a claim, I'm not going to take that to the commission. I'm just going to dispose of that myself. Or if I'm getting no cooperation from the other side, they won't speak to me, I'm not taking that to commission. That goes to the prosecutor's office. So that's what I plan to do. One reason also that we're doing it this way is we don't know how many complaints, what kind of complaints we're going to get. We could get a lot of complaints, or we might not get very many complaints. And so it's very difficult for the mayor to decide on exactly how to do this until we have a little bit of a track record and we understand what kind of job and what kind of time this particular position is going to take. And we just won't know that until we start doing it. So that's what I've got in relation to that, Mayor.
Okay, there have been some questions about the definition of socioeconomic, and do you have that?
I do. That was more difficult. I've been working on this. These are hot off the press. or off the Xerox machine. So let me give you a few to send down that way, if you would. There are several issues. Socioeconomic background was probably the biggest. First, I want to note that the city attorney has been designated by the city council in our Fayetteville code as the official interpreter of the Fayetteville code, except for the Unified Development Code, and then we've got city planner for that. But for this section, the city attorney is designated as the official interpreter. It says the Fayetteville code shall be interpreted by the city attorney. And because of that, I felt like I had not only the authority, but also I felt like I had a responsibility before this ordinance ever actually goes into effect to state what some of my beliefs are, some of my interpretations are in relation to especially a term like socioeconomic background, which was not defined in the ordinance. The ordinance defines many things, but even in the original ordinance that was provided to us by the the Human Rights Campaign, there was no definition of that. I called that to their attention, and they sent me an email, or I think I actually sent it to Alderman Petty, and he gave me their email, and I have quoted from that email in there to show what they initially told me, what that meant, and that it did, and what it did not mean, almost more importantly. And it did not mean that a landlord or someone offering credit could not have a credit check or a pay stub or some other credit history like that they would not be able to rely upon that. And therefore, I thought that that was okay, and so I didn't further question that at all when it went forward. There was some questioning of that actually during our marathon meeting by Marshall Nye, an attorney representing a business, and he was concerned about that, and I said that night, or that morning I guess I should say, that socioeconomic status should not be confused with socioeconomic background, and this one talks about background, not status. Status meaning, in my own mind, something current. And so my interpretation of that is that no financial institution, landlord, or business offering credit or other such person or business would violate the Civil Rights Administration chapter for using a credit check, requesting a pay stub, or otherwise asking for proof of ability to pay, and relying upon that economic evidence to determine whether or not to loan the money, to extend credit, or to agree to rent to an individual. My belief is that socioeconomic background refers really to where someone kind of came from. Did they come from the wrong side of town? Which I don't even know if they got a wrong side of town, I hope not. I think really socioeconomic background, I think it's more applicable to places other than Fayetteville. I think that, we don't have a ghetto, we don't have slums. And maybe this would be a problem in some cities where there would be some stigma attached to somebody if they came from a ghetto or a slum. Fortunately, we have been blessed not to have that here in Fayetteville. And so even if someone grew up in a deprived state, lived in public housing, maybe their mother was a single parent and had overdue notices all the time, that child who came from that poor socioeconomic background, if that child has gone out and gotten a job, made and paid the bills, then they certainly should not be discriminated against from where they came from. And so that's what I believe is the proper interpretation of socioeconomic background. It's not the current ability of someone, it's not their credit history, it's in fact where they came from.
Mr. Mayor,
Yes, ma'am.
when would it be appropriate for us to ask questions?
When he gets done.
So I just have a couple other ones I wanted to talk to you about. I was also questioned by another attorney representing businesses about subsection 11903D, where it seemed to that attorney that there was some issue about whether or not they had to issue job references. And as some attorneys and HR professionals will tell you, it's sometimes dangerous to issue job references because if you do a bad one and so that person can't ever get a job, well, then they might sue you and say, well, that's unfair, it really wasn't that bad. And then if you do a glowing one and the next employer finds out, no, this employee, stole from you and he stole from me, and so job references have sometimes been a somewhat of a danger for some businesses. Now, I don't think so always, but there's been some reluctance. And what I wanted to just assure this attorney and any employer is that the employer could have a policy say, we're not going to do we're not going to do job references. We're just not going to do it. We want to avoid any possible problem, so we're not going to do it. And that's totally okay. There's no problem like that. Or they could issue them or not issue them, and as long as it wasn't for a discriminatory reason, there's no problem there either. So really, you have to read the whole section of the statute, not just the little subsection, but you need to really read the first part of the section, which says that the listed sections below that, which one of them was having a failing or not giving a job preference or job reference, it's all modified for a discriminatory reason. So as long as it's not for a discriminatory reason, an employer certainly is free to do whatever they want to in a job reference. Or not do. They don't have to. Got a little concern from a CPA, not Tony. He's been nice to me and hadn't complained yet. But another CPA was concerned about age-type problems in relation to assisted living places. And it's probably the same for nursing home and some other facilities like that. My belief is that under the general exception section of this, we certainly stipulate that federal and state regulations can trump anything we would do. And so if a assisted living facility has a fairly comprehensive state regulations about their admissions and housing, who can be in there and how they can be selected, then that certainly is going to trump anything that we might say. We talk about no age discrimination except 55 and above. In some of the assisted living places, the age is lower than that for when they have to follow the state regulations. So I believe that that's probably, everything has to be looked at its own context, but I don't think that should be a problem for assisted living facilities. And the final thing I want to say is the sincerely held religious beliefs and whether a person, a minister, a photographer, a singer would have to attend a religious observance or ceremony that they don't agree with and because of their religious beliefs. And I think that we do have another provision in there, another section that talks about that and gives them rights. It's section 11907 in the general sections talks about when someone has a sincerely held belief. And obviously someone that is intimately associated with a religious ceremony would be exempted from having to participate in it or attend it or conduct it. And that's in my conclusion. In my memo, I also said I don't think there's going to be a problem. If I'm wanting to hire my wedding photographer, I don't want my wedding photographer to be someone that doesn't like what I'm doing. The wedding photographer's right in there to take pictures of me kissing my spouse, sharing cake, and doing all the rest of the things wedding photographers do. I don't want to have someone in there that would not be favorable to what my wedding is, be against my wedding. So I don't think it'll come up in reality, but even if it did, I think that they would be exempt from this. I want to say two other things. First of all, I want to still listen to other attorneys and other people who might want me to further clarify any interpretation or talk to me about how I did not understand something properly. I certainly have an open mind. I also want to say that my interpretation does not usurp a circuit judge's interpretation of the ordinance. Judges are granted the last call on anything like that. My interpretation is for how the ordinance will be administered. And as long as I am the administrator, in fact, as long as I'm city attorney, it will be administered in this way because that is how I interpret it. I also want to say the City Rights Administration Chapter was passed by the City Council and is always controlling, and no interpretation that I might present can change its clear wording. If the clear wording says something, then that's the way it is, and if it should be changed, then it must be changed by the city council. I cannot change clear wording in the ordinance, and I think that the 4 examples I gave to you are not any change in the clear wording, but just an interpretation of what can be unclear. So, though that is what I have opined to date, I don't want to make I don't want to continue to opine if I don't need to, but I certainly listen to any other individuals that might feel like further clarification is needed.
Okay, now we're going to take questions and input now. So be as brief. I'd like for you to, whatever questions you got, everybody will get about 3 minutes apiece to ask questions or make comments. I think that's fair. So, and then if we get all the way through, we're scheduled to go to 8 o'clock. We'll go a little longer if we have to, but not much over that. I want to keep us pretty much on time. Sue, I think you had some questions.
Yes, thank you, Mr. Mayor. First, let me say that I'm not in any way doubting that Kit is going to interpret this for city purposes the way you've just outlined. But in regard to socioeconomic background, since you have said that you are not a judge and don't have a judge's power and authority, and since you did question in the beginning the definition of socioeconomic background, why was it not included as a definition in the ordinance? Then it would be clear, because some of these, once you have given your judgment, may go on to a circuit judge. And there is no clear wording within the ordinance for socioeconomic background, and that continues to bother me.
Well, you need to understand, and I did cite that early on in the interpretation part, is that the Arkansas Supreme Court says that if there is ambiguity in an ordinance like this, then it is to be interpreted against the city and in favor of the person that would be charged under this. So I don't think the city will operate and the ordinance will be administered pursuant to these definitions and these interpretations. I guess you could say that someone that felt like they were being discriminated against and wanted to try to claim social and economic background as their source could try to take it to the court, but the court, I'm pretty convinced, is going to look at this and say if it's ambiguous at all, it's not going to be in favor of the person that's making the claim, but in favor of the person that would be facing the consequences. So I don't believe that that's a real concern, that it's going to be administered this way for at least the next 4 years. And I think that if you also just look at those terms and you look at the legislative history, because I did state on the record that night before the city council passed that it was not the same as socioeconomic status. I said it was socioeconomic background, which meant that it was not something that they could not get credit checks and things like that. So that's part of the legislative history. And so I understand your concern, but I don't think it's a real problem. Now, if you want to have the city council revisit this and put a new definition in you, and you can feel free to talk to the city council.
I appreciate your answer, and I'm confident that you will do this the way you have said you will do it. But my question was, why was this not defined in the ordinance, since the other elements were defined and since you had initial questions? Why was it not defined?
You have to ask the Human Rights Campaign why they did not have a definition of it in there.
I thought your office had revised and...
We removed some definitions. We removed one and some other parts of it. That is correct. But we did not write a definition for that.
And you didn't remove a definition for that?
No, there was no definition of that in the draft ordinance I was given.
That's all, Mr. Mayor.
Okay. Who else?
I have a question. Ann, good morning. The investigation that you do, what you do is subject to the FOIA.
That's right.
And so any of those investigations, I mean, anybody could come in and look at it. I mean,
if I create documents, that's absolutely correct.
How are you going to deal with?
I'm probably going to talk to the initial complainant. I'm probably going to call the person that they're complaining about, and we might have just a sit-down meeting between the three of us. Now, there will be some documents eventually created to some extent, and they are FOIable. And, you know, I have no trouble with the Freedom of Information Act, but I think in most of these other cities, they probably were facing some of the same issues. If I do a report, an annual report, I'm not even sure if I'm going to do that, Mayor, but if I do an annual report, I will not probably use any names if I don't have to.
I mean, the Arkansas Fair Housing Commission is also subject, you know, to FOIA.
Right.
So we, you know, we deal with that, but we also can mark things, and they have to tell us, there is a law that allows them, they have to tell us before it's released. They have to tell the person that's being complained about before it's released. We get to at least go and fight our stuff being released. That doesn't mean it's not going to be, but we at least get to, you know, told that it's about to be released to somebody and be able to fight that.
Well, I might notify the individuals. I'm not going to fight it. I believe in the FOI, and if I have a document it's not exempt on the FOI, it's going to be released.
And also, Ann, if we appoint a commission and they have their meetings here at City Hall, they'll be televised.
I know.
So I just want everybody to know that. So if you're heading down the trail of putting in a commission, which everybody seems they want this commission, but just be rest assured if this commission meets on one of these issues, it will be televised.
Can I have another question? Is my time up?
No.
I had listened to Mr. Olson talk about these other 4 cities, and I understand that they're not, even though they're going to commission, they're not, they don't send somebody to be criminally prosecuted. None of those are criminally I mean, is there, and I remember watching the night, and one of the alder people said, that it can be amended. I mean, this council, I mean, this is good, but I think that we need to do it in terms of like the other cities have and not have them be criminally prosecuted for something like this, that it would go, I mean, it can be amended.
Yes, it can. We'll leave that up to the city council.
Yeah, the council said we can amend this thing.
Well, let me tell you why the city prosecutor is even involved in this. It's like the city prosecutor will prosecute zoning violations. We have no other enforcement mechanism. We cannot create a cause of action like the state or federal government can so that somebody can sue. So the only way to enforce the city ordinance is have the city prosecutor enforce it, just like they do with all the other city ordinances, whether it be taxis or HMR taxes or zoning violations, barking dogs, whatever it is. We are a very limited government. We have very limited power. And the only power we have to enforce our ordinances through the city council, is through the city prosecutor.
I'm with you. Could I say one more thing? But
let's wrap it up.
It says to prosecute all cases, whether civil or criminal, that y'all have the authority to do that in your... So if it was a civil instead of criminal, it still says you have the authority.
Well, I guess you're reading our code there?
Yes, your city attorney legal department code.
Well, I don't know. In other words, when they talk about prosecuting a civil case, that would be, and I can do that,
The city ordinance.
but that would be a case that already has standing that I can do it, like if we're doing a condemnation. Well, I can prosecute a condemnation because state law says I can do that. We can sue somebody on a contract. I can prosecute that kind of case because it's a contract action and the state says we have the right to do it. We can't create a new cause of action. The city doesn't have that power. The state can create a cause of action. That means something you can sue on. The state can create something you can sue on. The federal government can create something you can sue on. When we looked at it, our decision was we don't have that power.
Okay. Mark, I think you had a question.
A comment and a question.
Sure.
Mr. Mayor, first of all, I want to tell you that I'm very proud to serve on this committee. And I also want to state that I believe in the truth that we are all created equal. I understand the purpose of this committee is to work together to help come up with a way to implement this and to give advice which can be accepted or rejected. And I do think it's very positive that steps are being taken to define terms, and now I see the structure as if it's not defined that KIT has that authority to do so. I do think socioeconomic may need a little more clarification, and this is just a suggestion which can be either be accepted or rejected. I think the reason we didn't have a definition for socioeconomic is it's hard to define. If you look it up in the dictionary, it says it's a combination of social or economic considerations. Well, what does that mean? So And, if you have a law and it's going to be enforced, there has to be some notice of what it is for it to be enforced. So I think for your consideration, I would point out that economic refers to wealth or income, so that's pretty clear. Social refers to rank or status. Rank or status is often determined by one's education and occupation, or their family's education or occupation. And so for that reason, I would suggest that you consider that this particular term be understood to prohibit discrimination based upon one's income, education, and occupation, or their family's income, education, or occupation. The part that you put in, making it clear that it doesn't prohibit, credit checks, I think is helpful, but that goes more to what it's not than what it is. And I think this would be more helpful in pointing out what it really prohibits, would be my suggestion.
If it said socioeconomic status, I would agree with you, but it says socioeconomic background. And in my opinion, when that question was brought up, originally the campaign or the Human Rights Campaign attorney made a clear distinction between status, which is something that's currently here, like your occupation, and something in the past. So if I use your definition, then you might be able to say, or somebody might be able to say, well, I didn't get a loan because my social economic status, I wasn't making as much money as Joe Blow. Well, I think banks might want to actually look at what somebody's income is. And I think that that's fair to do. So my main distinction, instead of defining social economic itself, was to look at the difference between currency, status, or background. Where did you come from? I think otherwise we're going to make this an extremely broad term. Although, I certainly think that, you define socioeconomic very well, and I'll be happy to look at that and maybe further clarify this if you want to send me that kind of language, but I can't agree with the fact that a bank or a landlord could not look at the fact that you're a successful lawyer, you're a banker, or are you someone that might not have enough money to pay because your income is lower. And I think that if we try to say that a landlord or a store lending credit can't look at your income, then that's a problem.
And one more comment, if I may.
Yes.
And I agree with what you're saying, Kit, and this was not an ending point, it was a starting point. I do think some clarification is needed because I not only believe in the ordinance, I want to see it succeed and I want it enforced. And if there's not clarity in what it is, I'm afraid we may have an ordinance that may not be enforceable, and people are getting away with it because they did not have sufficient notice of what it is. So, and I appreciate your comments. I'm happy to be on this committee and to work to provide that clarification and work together.
Mark, I would love, it seems like you have that written down, so that can go into the written as you have it in your recommendation, and we'll have that for the consideration. Sure. That's great.
Yes, Maria.
I've got a few things. On the socioeconomic background thing, I think we're forgetting the word perceived. I know you said you don't think we don't have any slums. That's not really, that doesn't matter, because what matters is from the person who's being discriminated, it's how they're being seen by who's doing the discrimination. So it doesn't matter that we don't have slums or a wrong side of the tracks, does that person treat me differently because they perceive me to be from the wrong side of the track? So just kind of on that point. You mentioned a couple of times that you were going to intake the complaint, and then you were going to call the person who was being complained about. I would urge it to be an in-person, that would be the process, that it would be equal footing. Mostly because it's not, you can't take in the information the same way if you're getting the complaint in person and then you're calling another person saying someone has complained about you. The body language, the nonverbal is hugely important. And I would just set that as like just set an appointment. This happened, can you please come in and talk to me? And take the.
I could invite someone in, but obviously I couldn't.
Well, yeah, you can't make them come, but that would become part of it. And I know you are a reluctant participant in the process, but I think it's important to keep statistics, and reporting is going to be hugely important. And whether that's something that's passed on to a staffer, or we come up with a way that it's going to be easy for you to take that information in, I think keeping track of it is going to be essential. Because as someone who has been discriminated against and others don't see it, it's the numbers are going to be, and whether that's 5 or 500, whatever that is, we need to know so that it's visible, because right now it isn't. And then a question that I don't know if it's covered, I don't know, what would we do with egregious offenders, reoffenders? Like if someone keeps getting, like, is this something that can be escalated in some way? Is this, I mean, are we going to then, if it's a landlord, let's say, take, I don't even know if you have to have a license to be a landlord, but like just do something in a way that if it's someone that's not curbing their behavior, that they're doing it purposefully and continuing to injure our citizens, are we then going to take a stand as a city and say, you know, this is the 50th complaint and it's found to be, you know, believable, we can't have you do this in our city? Is there some limit that we're going to set?
It'll be up to our court system, the district judge, the city prosecutor. Obviously, when you have offenders that continue to offend, no matter what the violation might be, the amount of fines usually goes up. The promptness of prosecution usually increases. But I will leave that up to the city prosecutor and what the city prosecutor's judgment, and also, of course, up to the district judge, who is the one actually that announces what the fine might be.
Then, in the process, the intake, and how we actually implement, will there be a time, a deadline for what the next steps will be? So you set a complaint within 7 days, you're going to get what we've done with the complaint. And the main reason is it tends to be, if there's not deadlines or, time stamps, it tends to kind of drag on. And when you're being subjected to this, you actually want a resolution. It takes a lot of courage for people to come and say, this is happening to me. And for it to linger is doubly injurious. So I would say when we implement and whatever we write out the process, that we're very mindful of putting timelines in place between steps so that it doesn't just linger and people don't feel like it's not going anywhere. And my last point is, I know we mentioned sincerely held religious beliefs, but I would like to say businesses offer public accommodations, and racial discrimination and non-miscegenation was perpetuated and supported by people who grounded it in sincerely held beliefs and sincerely held religious beliefs. And so I think we need to be very careful, whereas I agree with you, I'm not giving my money to someone who wants to discriminate against me. I also, if you're offering a service to everyone else in the room and I can't have that service, it's a publicly offered thing, my money's just as good. And you don't have the right to tell me you don't agree with my life. You're offering a service. You don't have the right to tell me that my color, if I were married to a white guy, there's still people who wouldn't do that. And so I think we need to be really careful by saying, oh, if you have a strongly held, I'm a religious person. I understand having religious belief, but that could be something difficult and hard to It may not be something that we can cure, but it's definitely not something that we should overlook.
So on sincerely held beliefs is your recommendation?
The sincerely held religious beliefs, it's safeguarding, and the example that he used was like if a photographer doesn't want to do your wedding because it's a gay wedding. Well, if he said he didn't want to do your wedding because a black girl's marrying a white guy, would we stand for that? That's my point. It's like
It needs more
if there,
clarity, or it needs
well,
more that's in the process?
Well, that we don't just simply say you get a pass because it's a religious. If you're offering a service, if you're offering a public service, I mean, I was in a public store speaking in Spanish, and people were treating me differently because I was speaking in Spanish.
Take it serious.
So take it seriously, because you just never know if, like, people are using that as a cover, so.
Okay. Danielle, you had your hand up.
I did. The question about referrals, and I know Kit, you talked about that earlier just a little bit, or I think Leif talked about that when he was talking about some of the peer cities, but will we at any time, if there's an issue that does arise as it relates to employment or any other issue, that we will actually refer issues to any federal agency, state or federal agency? Will we do that?
Well, I would refer the complainant.
That's what I mean.
If they come in and they really have an employment problem, and it appears to me like they have some validity to their complaint for any kind of reason that's protected under federal law, then of course that really shouldn't be handled at this tiny level.
Absolutely.
Where we have virtually no power except for talking to people to try to get them to resolve it. Instead, it should go to one of the federal agencies, and so that's certainly something that we would do.
So you would refer them, not so much say you have a right to go, you would actually say this is who you can contact?
Right.
Okay, no, I just wanted to be clear on that. As far as the ordinance talks about retaliation,
Yes.
is there anything, I was looking at the form, and I know this is a draft form.
Now,
but
that's not my form.
I know, I mean, I understand it's a
Just
draft.
keep in mind, that's just a draft.
Absolutely, absolutely.
And I didn't participate in that draft.
No, I understand,
That's
I
from planning.
understand.
Well, I participated a little.
But as
anyway.
far as retaliation is concerned, because of course, that's based on something that has allegedly already occurred as it relates to discrimination. So if there hasn't been a finding, or if you haven't made that determination, how is that going to be dealt with as far as retaliation is concerned, if they're coming back and something hasn't been referred yet? As far as if there's a timeline of something established and somebody said, well, they're treating me differently, they're continually doing this, how is that going to be dealt with? It's just going to be compounded?
I don't think there has to be any particular finding before there's retaliation. There can be retaliation just because I call the person back up, or they come and visit me.
Absolutely.
And they say, well, I'm firing that employee.
Right.
So, but at that point, it shouldn't be us, because that kind of retaliation probably would be something that would be violating and the EOC should probably hear about it if it's that serious, where somebody gets fired for trying to assert a civil right. But if it was outside the jurisdiction of the EOC and only within our jurisdiction, that would be something that would be referred to the prosecutor.
And the last question, Mr. Mayor, I apologize for being long-winded. Just ensuring that any individuals that are, I'm trying to say this politically, that are non-resident, or those that are not citizens of the United States, undocumented, thank you, undocumented, will they ensure that they have the same rights as everyone else?
I didn't see this ordinance being limited to citizens.
Okay, I just want to make sure that was clear. I didn't see that definition or anything in it. I assumed that, but I just wanted to make sure that I was clear on that.
That was my assumption as well.
Okay.
Okay, I'm just writing stuff down here. Hang on. All right, who else? Kim.
Hi, I'm going to pass around a memo because I don't have time to sort of talk about it all tonight. But first, thank you for letting me be part of this group. I think I was invited to be a part of this group because I work for an international law firm that focuses exclusively on representing management in labor and employment law matters. So as a starting point, I'd like to say that discrimination in the workplace is wrong. We should do all we can to prevent it, and that's what I do on a day-to-day manner. I help ensure that employers are treating their employees fairly, adopting policies and procedures that are fair, helping them make legitimate, non-discriminatory employment decisions. But in general, employers need to know what the rules of the game are, how things will be handled procedurally, how terms will be defined and interpreted. My practice consists almost entirely of representing employers before the EEOC in state and federal courts on employment discrimination matters arising under Title VII, under the ADA, under the Age Discrimination in Employment Act, under the Arkansas Civil Rights Act, licensed in Oklahoma, so under the Oklahoma Non-Discrimination Act. So the implementation and interpretation of the ordinance is of considerable interest to my clients. The memo that I circulated broadly identifies some specific provisions in the ordinance that may not provide enough information to employers to allow them to know how these new rules are going to be implemented. Some of those comments in my memo have been addressed by Leaf, by Kit, but I think that there's still a lot that could be talked about. First, in terms of the procedural process, the ordinance, as Kit has identified, doesn't clearly set out the procedural process from the filing of the initial complaint with the with the Civil Rights Administrator, from the time the complaint is referred to the City Prosecutor's Office for criminal prosecution. My memo sets out several bullet points for procedures that aren't specifically spelled out in the ordinance. I don't have time to go through all of them, but a couple of examples. Like Maria was saying, it's not clear when the employer is to be notified, what the timeline is when the employer is to be notified of the complaint by the administrator. For example, the EEOC is obligated to notify an employer of a charge of discrimination within 10 days of its filing. One question might be is whether the city foresees that sort of timeline happening as well. How long will an employer have to respond to a complaint? Will the administrator have the authority to conduct an investigation? You've addressed that a little bit, in which witnesses are going to be interviewed. How long will the investigative process take? How long will the city prosecutor have to file charges? Well, you talked a little bit about mediation, but I think that that the idea of offering mediation as an option could be clearly spelled out. When complaints are filed. Anne mentioned FOIA. How FOIA is going to be applied to the investigation, I think, is something that we need to talk about. Kit explained that FOIA does apply to the investigative process. Again, in the EEOC dealing with a charge of discrimination, all of that is in fact confidential. This would not be, because it would be subject to FOIA, so I think that's something that is relevant to how the employer is going to respond to an allegation and deal with that. There's a lot of information in this memo, and I'm sorry it's so detailed, but I've outlined several areas where I think additional definitions would be helpful. A lot of folks have talked about the socioeconomic background issue. My research has shown me that no other state, federal, city, that's not a protected category anywhere else. Since it's so new, I think we really need to focus on identifying exactly what that means. Does the ordinance provide a duty to accommodate disabilities and religious beliefs? The ordinance does not seem to provide any affirmative defenses that are available under state and federal law that would be available also under this ordinance. A big issue that comes up in the Arkansas Civil Rights Act context is the liability for individual supervisors. It's perhaps an unintended loophole in the Civil Rights Act, but individual supervisors can be subject to liability under the Arkansas Civil Rights Act. It looks as though that's an issue here, but here individual supervisors could be prosecuted, not just brought forward under civil charges. So would individual supervisors be prosecuted, or would just the employing entity be prosecuted? Another issue, will gender-specific dress codes be permitted? Is pregnancy included within the meaning of gender? It doesn't appear to be under the ordinance, but it is, in other areas, it is a protected category. So there's a lot of things I think that this committee can think about and work through. Again, I really appreciate being part of the committee. I appreciate the opportunity to discuss how Fayetteville is going to implement things.
Thank you. Who else? Yes.
I just want to thank you for letting me sit on this panel, and please forgive my ignorance. I don't have a law background. I don't know. I have not finished university yet. But I did have a couple questions and a couple comments, if you'd be willing to clear those up. I know that you made very clear that you are not going to be the investigator. Are there any plans to who is?
Basically, the way I view the civil rights administrator is that there is no in-depth investigation at this point in time. It's basically getting the information from both sides, meeting with them, and seeing if something can be resolved. If that cannot happen, then at that point, I think it will go to the city prosecutor. The city prosecutor has additional resources, the police. The city prosecutor has subpoena power, although if they subpoena someone in, they have to advise them, they don't have to speak to them. And they have to waive their Miranda rights, and I used to be a prosecutor, and I've done that. I've subpoenaed people in, mainly witnesses, as opposed to suspects. And you don't have to Mirandaize them, because they're not a suspect. But no, that's not how I view this particular position. I don't think this position is, I'm not going to be doing in-depth investigations about what happened. I'm going to listen to both sides. I will act fairly quickly. In fairness to the campaign, or the Human Rights Campaign, they had about 4 pages of procedures that they wanted, step by step, about 20 steps or something, that they wanted the Civil Rights Administrator to go through before it would ever be referred anywhere else. And I don't like that. This is only an ordinance. This is the maximum penalty on something like this is a fine. I think that I will keep some statistics, but I am not going to, I don't like procedures which says, well, you've got 10 days. If you don't do it, then somebody's off the hook because you didn't do it in 10 days. I think it's going to move much, much faster than that, but I'm not going to establish those sorts of policies and procedures within this. I don't have them now for when other issues come before my office. I handle them as I can. The employer will certainly be notified before anything happens, because I always want to give them an opportunity to tell me their side of the story. It will probably be much faster than 10 days, but I'm not going to put that down in any policy, because I don't, number one, the Civil Rights Administrator has no power. We can't file charges. We can't do anything. All we can do is try to get the sides together and see if we can resolve the issue. And if we can't, it goes to the city prosecutor's office.
Well, the reason why I bring that up is, I don't mean any disrespect to anybody, but it kind of feels like we are doing the direct opposite of a lot of things that these cities with successful ordinances are doing. I do like that you said that you're going to be keeping records, because as she said a minute ago, that's the only way some of us have any proof. You know, I've heard a lot of people say, well, I don't see that happening. No joke, you don't see it. We've got to keep up with numbers. And that's also the only way we're going to be able to really tell how effective this is being, is, are we getting complaints? Why not? Why are we getting so many? Are they actually being resolved in a satisfactory fashion? If not, what can we do about that? I very much believe that keeping records is an important part to making sure that this ordinance does what it's supposed to. I did have another question. It seems like the outreach campaigns are important to the success of these ordinances. I feel like it would be helpful, not just for your workload, but to make sure that this gets handled by the appropriate people. If somebody did like an education program to know your rights, be able to tell, are you being discriminated against, what is not considered discrimination, and if your office is not able to handle it, where are we supposed to go? I know that I haven't been a disabled person for very long, but I have no idea how to get in touch with my local ADA representative. And I haven't had a lot of luck asking around how, because I have had problems with that. So I think you can curb a lot of issues that you either don't have the power or don't have the resources to deal with by directing people where they need to go. So thank you for hearing me out. That's just what I thought about it.
You're very welcome. Thank you. Yes, Ann.
First, I want to start off by thanking Mr. Olson for your great research on this. And you too, Mr. Williams, for your willingness to take this on in the heat of all of this. And Mr. Mayor, for you following through with your promise that you will tackle this and do it effectively and quickly. And convening this as part of that. One of the things I noticed in looking at your research, Mr. Olson, a couple of different things stood out to me. One is that most of these commissions have been around a long time in these other 4 cities. One's even almost as old as I am. So I commend us for coming up into modern day. And also one of the things that I noticed, and to me this kind of get rid of some of the fears that I heard during the public comment, and that is most of the cases that were brought before were really dealing with race or age, not with gender identity or expression or even sexual orientation. And I believe that would be also true in our community, just like it was in these communities. And I guess what I'm asking and really want to assert is that we do have some sort of commission formed to deal with this, that it not just be all on the plate of one city employee, for many different reasons. One being that I think there's a lot of work involved in this. A lot of these questions that we're asking today could be handled and better defined and looked at by an entire commission or board. I know from my past history that there are comparable boards. There's precedent for this type of thing. Let's look at the telecom board, for example, that was really put in place around a controversial issue before the city in years past. And that board was sort of the body that handled all these questions and looked at these issues and then advised the city staff person. And I think that's really needed here. Another reason, obviously, we have a lot of legal questions that are before us with regard to this type of ordinance. But there are the legal issues, and then there's the real or perceived fairness aspect. And the fairness aspect, when you're talking about any issue like this that affects people who are not in the majority or dominant culture group, it's hard to see that fairness is really going to be done if one overworked man who does great work anyway is the only person in charge of this. And so having a commission or a body of people that not only have the legal skills but also the real life skills to really reflect the folks that are going to be affected by this, I think is so vital, not only to make sure that it's done correctly and to inform Mr. Williams and the administration, but also to make sure that there's representation. I very much value the city council and the mayor, and it's also a bunch of white folks who make the rules in this city still. And I think having a commission of folks that aren't just the white folks making the rules, if I could speak plainly, is really important.
You always do.
Well, that's why we love you. And I say that as someone who is obviously white and wants to be an ally, and also someone who might be affected by this ordinance, and also someone who is an employer. It's so vital that we get this right. And I don't think it's fair to put that all on the weight of one city worker who does a great job in the job description that you already have. So I would really say that even if we approach it from the same precedence that has been set by the telecom board, as not just the commission that's going to, I think, investigate some of these, help some of these issues be resolved, but also as a body that can help form this moving forward so that it is best practices and that it really is helping Mr. Williams in his job in this first year. So again, my gratitude. I really want to ask you, how serious are we about some sort of commission or board, and what would the process look like to create that?
Well, I'm actually pretty serious about the commission. I've really been considering this for a while, since we started on this. And when we did the studies and they came back, it showed the most successful cities have had the administrator, but they've also had a commission in place too. Now, I'm still pondering that.
Sure.
So, but I will have that decision made pretty quick.
Great.
Okay?
Yeah.
I just got to figure out how I would put it together.
Well, thank you for considering.
Absolutely.
I would like to second that. For one, it's important that the minorities stay involved in this picture, not just here today, but also ongoing as we continue. I also have a question for Kit Williams. What do you think the turnaround would be for a complaint from beginning to end, a range?
I would actually think it'd be pretty quick. As an attorney, I've often had to write briefs and do other things like that, and I look at many of my contemporaries, and I'm sure it's not my lawyers up here, but a lot of my contemporaries will ask for continuances. Get continuances from the Supreme Court for this, so they don't have to file their brief, or other continuances. And I've always felt like that's just wasted time. You might as well get it done. So I think that it will, in a normal case, I think it would come to at least an initial determination in my own mind about whether there's anything involved, anything that might need further clarification within a week. Unless, if I don't get any cooperation, if I try to schedule someone to come in and they don't come in, then I will probably give them a second chance, but that will slow down the process. But there's really, and it also depends kind of to some extent, do I have another brief that's due that I just have to finish before I can go on to other work?
Yeah.
And of course, there's other things that the aldermen are asking me to do, new ordinances and new other things like that. It sometimes get in the way too. But I think normally, I would believe that most times when I would get someone coming in and making a complaint that has at least some validity, something within the ordinance, I would think that within a couple weeks, there would be at least initial determination. Now, my determination might be is that this is a more of a confusing and difficult case, and so this was one I would want to take to the commission. Now, obviously, that delays things because you've got to look at everybody's schedule, try to find a time that everybody can meet, including the complainant and the other side, and so you double the time at least if you bring the commission in.
Yeah.
And so then you're looking at, maybe a month at that point in time. But I would venture to guess that 95%, if not even all of them, are going to be done within a month. And I think the vast majority will be through with my office probably in a couple of weeks. Now, you could find one that's much more complicated than I'm anticipating that could take longer. So I hate to say that because we haven't got any yet. So I don't have any track record. I'm just kind of shooting in the dark here and wondering when I'm going to hit. But I'm not one for letting things fester and delay because you just get farther behind. In my office, you can't afford to get behind because you'll never catch up.
One more thing. I have to agree with the confidentiality part of that, reporting and so forth. It is important in fear of retaliation, things like that. However, it is probably more important to have some form of documentation to repeat offenders with the same person. So a lot of my community are at work dealing with discrimination day after day after day, and nothing's getting done. And even if they report it, if they don't get, it would become a very repeat issue. And I do feel that it is important for that to start adding up, that weight. So some form of documentation, I think, is at least.
Well, there certainly will be documentation. We'll certainly, and the city prosecutor will certainly have documentation because everything becomes a matter of public record, and it's a case that would be filed and would go to court. Now, once it goes to court, that will take more time because then it's a criminal procedure. And so the city prosecutor can have a citation issued and get the case underway once the citation is served. But then there is a delay for a couple weeks before the first arraignment. And then after that, you've got usually 2 months before there's a trial. So if it goes into the actual criminal process, it will take more time. So when I was describing about resolving any complaints, that meant resolving them in my office as the civil rights administrator, being able to work something out, being able to come to an agreement that whatever was going on was either correct and can continue or needs to be changed in some way in order to comply with the ordinance.
And the Freedom of Information Act applies to documents, so we get complaints and recommendations every day. Most of them come in through the phone, and then we resolve it and say the sidewalk needs to be corrected. Some of them where we have written forms, or like through our animal shelter. Somebody reports a barking dog. They don't want to be turned in and say, oh, I did the complaint, but if it's in the form, it is subject, it is a document that would be in there. So it's not something that the city hasn't been dealing with, I think, over the past 100 years. I mean, we have that, but it would fall in line with some of the routines that we have now. And if it is a document with exceptions, depending on certain privacy elements, there are exceptions to the FOIA and everything.
But not
then
much.
It would be
Don't count on that.
There's not a whole lot. And that's where I know the mayor wanted recommendations too, like on the form, and I know Kit's going to do a form, and you know what should be in the form and everything, and that could be helpful as well.
Yeah.
Well, one, Mayor, thanks for having this meeting. I think on the list, and thanks for Kip for defining some of these, you've taken a few off the list, but one that I think still needs some definition is the definition of a contractor with the city. This applies to all contractors doing business with the city. Does that mean a formal contract? Does that mean somebody seeking a permit? Further, are contractors going to be banned from, if they're chronic offenders, from doing business with the city? And if they're banned, how long are they banned? You know, there's a lot of questions that can come up depending on what the definition of that is. The other thing that I would say is that there's not, it seems to be, there isn't an appeal process in here anywhere except the courts. And, you know, if you go through the planning commission, the city council is your appeal mechanism. And there doesn't seem to be that mechanism here, which I think for everybody involved, it's always better to stay out of the courts, and we don't want this to turn into the Attorney Full Employment Act.
Well, let me say, when there's a zoning violation that planning thinks that there's over occupation of a house, that's not ever able to be appealed to the city council. Instead, that goes to the city prosecutor to enforce the ordinance. And that's exactly the same case here. It's not like the city council is going to say, ignore our ordinance. They can't say that. That ordinance must be in effect until they amend it. They can amend it or repeal it, but they cannot say, ignore the ordinance, just like I can't either as city attorney. So the appeal process is through the courts, through the district court and the circuit court, or a brand-new trial if that has to happen. But there really is not a place for the city council to place themselves in this position, especially trying to appeal something that the commission might decide or that I might decide, because in reality, all we're doing is either making a referral to the prosecutor or not. And the prosecutor can take the case either way. In fact, if no referral is made, if I just say, well, I don't think you have a case, but you can talk to the prosecutor can disagree with me. The prosecutor say, oh, you do have a case. So there is this civil rights administrator, I'm put in a position where in reality I have virtually no power. Maybe I have a little persuasive power. That's the only power I have. I have nothing else. So there's nothing to appeal. There's no final decision I make that really is worthy of an appeal, in my opinion.
And contractor, you want to...
But we do need to look at the contractor's language. I don't think it would be as low down to somebody getting a permit or something like that. Somebody doing business with the city, I think, is what the city council was looking at. And, you know, I think...
Well, I'm not sure what that...
Well, we'll define that. I've got a question mark beside that, too.
And there's nothing in the ordinance that gives us the right to ban anybody. The only thing we can do is refer to the city prosecutor for prosecution. We don't have the right to ban people. Now, I will say, we have another ordinance called the business license ordinance. And the business license ordinance can sometimes be revoked for people that disobey city ordinances. That's a whole different process. That's not me. I'm not the administrator who does that one. You have to look at Jeremy Pate. He's the one on the hook for that one. I don't think we've ever revoked a business license, but it doesn't mean that it will not happen.
And city contractors, correct me if I'm wrong, I mean, we consider those as like your media, who contracts for our public access television, CH2M Hill, who is our contractor for. So in the city, we've always referred to as the contractor being the person
That
that
is
the city
probably,
contracts
you know,
with.
if it's not defined in the ordinance, and it is not, then you just look at the normal dictionary definition. And as I said, if there's ambiguity in the city ordinance, it's not going to be construed to make it broader. The courts will construe it to make it more narrow.
Somebody, Lola, did you have your, who else? Is everybody?
You've already used up your time.
Wait a minute, Mark, let me get a couple other folks. I'm so happy I appointed all these attorneys. Anyway.
I tried to warn him.
Yes, you did. Okay. Anybody else? And we'll start again. All right, Mark, let's start with you again.
A question for Kit and then three more suggestions. Kit, there's some of the questions I'm hearing tonight kind of sounded as if it wasn't real clear that we're prohibiting not only discrimination but perceived discrimination. The purpose, I think, really makes that clear. Is it your interpretation that all these different examples of discrimination also include perceived discrimination?
I wouldn't go so far as to say every one of them, and I'd look at the actual definition of discrimination as opposed to the purpose of the original ordinance. So you can look at the purpose to some extent, but I think that the most important wording is the definition of discrimination itself, which was slightly changed. Originally it said basically had no intent component, whether you could do it by mistake, and I felt like that was probably not right, especially in one that might be enforced by the criminal law. There should be, you shouldn't just be punished if you by mistake do something that might be discriminatory. And it wouldn't happen anyway, because I would call the person up and say, do you realize what you're doing? So please don't do it again.
Then three suggestions, Mr. Mayor. One, with regards to freedom of information and privacy concerns, I think that needs to be addressed. Another suggestion is some more clarification in some of the terms. One of the terms is physical characteristic, and
I don't think we got physical characteristic in there anymore. Do we?
I was thinking we took that one out, but did you find that in there?
The copy I got had physical characteristic in it.
Okay.
Yeah, I think that was one of the ones I was able to get them to actually remove in the final copy. There's no definition of physical characteristic. It was a definition of physical characteristic that I couldn't be sure of what it meant.
So the copy I had, I thought was the most recent one.
Is it a 4-page one? The code section?
Yeah.
Oh, it's, let me give you,
Well, let's make sure everybody's got the same copy.
Okay, this is
The copy in this book is the most recent.
Yeah.
1904.
Okay, let's take a look.
Hi.
I just printed this today.
It's in,
There we go, right
Yeah,
there.
it's still in.
Middle of 119.4I.
Okay.
Yes, it is.
Well, assuming it's still in, I just had a suggestion.
Okay.
I think it needs some clarification and is probably worthy of a definition. And again, you always go to the dictionary first, and that describes physical as involving a bodily as distinguished from the mind or spirit. Characteristic is defined as a distinguishing trait. So I'm coming here with some suggestions, and one would be to define it as discrimination based upon a genetically controlled or determined bodily trait.
Well, I can tell you that it was left in there by mistake.
Okay.
we had significant discussions, I did.
Yes, we did.
With the lawyers from the Human Rights Commission and Alderman Petty, and we agreed to remove physical characteristic, which had a long definition, which I still felt like I didn't know what it meant. And so, basically, it's a scrivener's error that it was even included in there.
Okay.
And I will confirm that with the sponsor of this, but I think that probably should be stricken before it's codified, because it was not intended to be left in the ordinance. It was intended to be removed, and we did remove the definition and other places where it appeared, and we missed it here.
Got it. Well, then we don't need to clarify something that's going to be removed.
Well, I couldn't clarify it. You could try to clarify it. I could not figure it out.
I had a little bit of issue with that one, too. I couldn't really figure it out.
And my final suggestion, Mr. Mayor, is I feel strongly that a citizen commission would be helpful. This is too important of a task to not have a broad section of people participating in to make sure it's workable, to make sure this lofty goal is realized. And there are going to be cases that are fall in the gray area. And it's helpful to have more input in those situations, and I would urge you to give that strong consideration.
Okay. What else we have? Yes.
I've been thinking on it, and I had a wording question that you brought up earlier, Ms. Coates. I think you said something about pregnancy. Would that not fall under familial status?
I mean,
Sorry, I didn't.
No, that's fine.
It just seemed like it would fit there because, oh man, where'd it go?
In the family way.
I mean, the recommendation would be that it would be expressly included in the language.
I can't find it in here, but, oh, here it is. It mentions, I just saw it. That's so ridiculous. In 119.02 definitions, letter G, familial status means an individual's status as a parent or legal guardian to a child or children below the age of 18 who may or may not reside with that individual. I mean, I know that sounds weird, but it seems like it would fit there. And I do feel like the definitions that Mr. Williams gave about socioeconomic status and background were very clear. But then again, I'm not a lawyer. It just made a lot more sense explained that way.
You know, I just can't explain it to them, though.
I'm sorry. I'm sorry, I didn't mean it that way. Okay, I'm going to be quiet forever now.
You're not the first one, kid.
No, I do agree with everybody that said before that I just lost the word. It's embarrassing. A commission would be a great way to handle this, so maybe not all the pressure is on Mr. Williams. But yeah, that's all I had to say. Thank you.
I'll make a determination on that. Yes, Ann.
Mr. Williams may have said this, but I don't remember how, we're a management company. I certainly don't want to bring mine into it, but ours are owned by a lot of different property owners, the properties that we manage. How are you going to notify the property owners? You're talking about calling somebody up. I mean, if we have something that a manager or a leasing consultant did.
I'm going to probably go directly to whomever was acting in a potentially discriminatory manner, which would not necessarily be the property owner. I think it is going to be the person that actually did it, which would be the manager. And that is going to be the focus probably of this, because that's the person that's doing the discrimination. We're not going after a property owner who very well might not know what's going on. They might find out if their manager gets prosecuted.
And I don't know about this, you may know. If you revoke somebody's business license, I mean, like a community, like a property that we manage, does that mean it closes down and all those 600 people in those units are going to have to move out?
Yeah, I think we kick everybody to the street.
I mean, that's kind of...
No, number one...
you revoke their business, their ability to do business, you close their doors. Yeah.
Well, we have never revoked a business license to my knowledge, and I'm sure that
we talked about that.
The business license administrator, who I am not, fortunately, will take into account something like that. And it would only be just because an apartment we've had problems before where it would affect other people. Like one apartment manager was collecting money to pay water bills and then not paying them. And they thought, well, we can't cut off water because all these poor tenants would be out. But you know, we figured a way around that. We cut off the landlord's water to his personal house for not paying the bill. Because we didn't put everybody else without water. So the city is not really stupid. We will figure it out.
I had to make that call.
And
Works good.
We stayed within the law.
Yes, we
We
did.
found a way we could just do that. And he didn't like it much, but you know what? The bills got paid.
Yes, they did. That's day-to-day stuff. Anyway,
You got a question?
Yes.
One last question. I promise.
yes, ma'am?
Kid, you talked about an agreement. That's your goal, is to get an agreement to make sure that whatever's going on is not gonna happen again. Is that agreement going to be documented in a certain way? And will they have to sign it? And if they happen to violate or decide that they're not going to adhere to the agreement, will you pick that back up again? And is there any, how is that gonna work?
Well, I'm going to play it by ear, really, on this. Part of it depends on how serious the infraction was initially. I can certainly see that might make sense in some cases, or maybe in most cases, to have a short written agreement.
Right.
As opposed to some of my brothers of the bar and sisters of the bar, my agreements are extremely short. I'm sure it wouldn't be more than a page. It wouldn't have all kinds of other terms. It'd just say, you know, we've agreed that this type of behavior that will be described will not be repeated, and that there will be no retaliation, you know, something like that. And I do think that in some cases, but maybe not all cases, but in some cases, a written agreement like that would be good. Obviously, that's also echoable.
Absolutely.
So many of the discussions I think I would have with the parties will not be in writing, will not be letters back and forth or emails back and forth. It'll be conversations on the phone or in person, so that I hope that people can be very frank and not worry about, you know, well, we'll just come back to bite them if it doesn't work out, because I want to try to have it work out where the discrimination ends and everybody goes on with their life. And I think that I have confidence in the vast majority of our citizens who want to do the right thing. I think there's very, very few people that we're going to have any problems with. That doesn't mean zero, because there will be some problems, no question about it. But I think the vast majority of people want to obey the law and want to treat people fairly, and I think that this ordinance will help in some of the areas that might have been gray and they didn't realize maybe that the times have changed and you can't treat people like that anymore.
Yes, okay.
This might be kind of a complicated question, but there's been so much focus on businesses and organizations. I want to take it down to a more personal level of, let's say there's two people that live in the same building of an apartment. This is something that's based off of something that actually happened. One tenant is making complaints due to discrimination to the landlord because the other person was trans. And repeatedly, over and over and over, to the point that the transgender person felt discriminated against and pushed out of the residence. And I don't really think entirely that, and I don't know, it did not happen to me, so I don't know if the landlord was actually the person doing the discrimination, but it was founded on the other tenant doing the complaining, repetitive. Can the ordinance help a situation like that? Can the ordinance focus on the person doing the discrimination, even though it's not an entity such as a landlord or business?
So person to person versus...
Okay, I do not think that this ordinance covers a tenant against tenant sort of situation. It protects tenants from improper actions by landlords or customers improper or employees improper actions by businesses. But it doesn't go so far as to try to protect tenant against tenant or in that kind of situation. There are other state laws about harassment that could possibly be affected by this, and some of those are also prosecuted by the city prosecutor. But then I also need to tell everybody here, government does not have all of the answers. We cannot stop every problem that ever arises. Some things we just are beyond our power because they're too complicated like that. Because we start getting into tenant on tenant, and it makes it extremely complicated. Who do you believe? What are the real facts? How can you punish a tenant for making a complaint when the landlord's the one that did the eviction? Now, if the landlord did an eviction for the wrong reasons, then the landlord is someone that could be applicable under this ordinance. But I think in the way you described it against the other tenant, I do not think, I can't say, we've not administered this at all. But I don't remember anything in the ordinance that would give me the right to go forward in a case like that. I will look at the ordinance every time somebody comes in, because sometimes, I don't have it memorized. In fact, I had a term in there I thought was out, and it's going to be out. But I don't think it would cover the scenario that you mentioned.
Okay, so instead of saying tenant to tenant, can we say person to person instead of business to person? Is there anything to protect person to person? Because there are a barrage of other discrimination stories, probably more so on people to people, in a lot of ways. So is there anything that protects people against other people?
Everything that has to look in context, but it's generally applying to someone who is in a position of power over another individual, an employer or a landlord, a manager of a business. Those are what it's directed at, as opposed to equals.
Okay.
There might be something else in the ordinance. I don't think there is, but I will not guarantee that it's not there.
Okay, and, all right, thank you. I will like to kind of add a statement about that council. I think if I understood correctly, the council is going to be there kind of as a second phase. So a complaint would go to you first, and then if it's a major conflict that can't be resolved right away, would go to a council. If that's the case, I think I like that for the sake of city budget, etc. Because I know that is a major concern. So, if we have someone to kind of weed out the simple cases, and then a council to, secure.
It's really more of a timing issue too, because we want to get these situations resolved. And so the simple ones that can be resolved quickly one way or the other, it's probably better not to have to take those to a council or commission, which is necessarily going to delay the final decision, if we don't have to.
Thank you.
Yes, look.
Just a question of clarification. We have the draft of some complaint forms, release forms and such. As I'm hearing you describe the process, that's not necessarily the absolute first step. Someone could come into your office or make a telephone call, and you'll sort of see if you can't resolve that without forms getting started that are FOIable. Is that the way I'm hearing it?
Kind of. I don't want to have as in-depth form as they have. On the other hand, I think there needs to be some documentation of the number of complaints I received. I will probably, in most cases, insist that if someone wants to make a complaint, that they actually come in and talk to me. Because you can see a lot of things like that, and I just do better talking to somebody in person than I do over the phone. And at that point in time, I will take down some basic information. Number one, I will take down contact information, so I will be able to get back in touch with whoever is making the complaint, and I'll take down some just basic facts about what is alleged to have occurred. But I'm not going to take down all of the rest of the stuff, and I might categorize it about what kind of discrimination it might be, what's category. So I'll have that, and that would be FOI-able, but it probably won't say too much. At that point, then, I would be contacting the other party and seeing what the rest of the story is. And I might not have to do anything further than that than write resolved on that form, or undisputed, or disputed, or whatever. I might not have to do very much more on that form. If it goes all the way to a commission, there'd be a lot more information.
I want to, again, insist that we absolutely have a form, and that the easiest way to keep track of things is to have a clear process that has delineation of categorization and, numbering things. And I know lawyers like numbers and tracking and all of that, but it's going to be critical to be able to keep track of what's going on in light of, if it goes into a commission. We don't want in a public setting to name person X, person Y. You would have to give them numbers as like complaint.
You're talking about in front of the commission?
Yeah, I mean.
We're using names. It's going to be real people. I mean, we can't make this a private secret sort of
I think
commission.
when paperwork is running around, I mean, and I don't, the EEOC, I mean, that's all kind of blind behind. You keep the information somewhere, you know who they are, but when you're discussing it in public, you don't share names. I mean, if they're in front of the commission, it's a different thing, but you don't share names.
There's no way that I can appoint a commission and it not get before TV.
No. What I'm saying is, as the process is going along, like in emails, you don't share names. That's just not, it's a privacy issue, it's a legal matter. I mean, when you talk about, patient and stuff like that, I mean, you just don't, you give them a number and you track it that way where it's like it can't get out. If they come out in front of people, that's a different thing. If you're going to have a process in front of people, that's a different thing. But when it gets to that point, people are aware. But tracking is vital, and privacy to the point that we can have it is also vital.
Okay. Hang on just a minute. Yes.
Let me
Tom.
just, well,
Yeah.
first of all, I think you made an excellent choice with Kit Williams. And then I'd also like to add, I know you've heard this probably 20 times tonight, that commission's a good, would be the way to go. I served about 6 years on the audit committee for the city, and that's a great committee, and we work well, with the city, and you can see hopefully the results, from that committee, and I think that kind of input from citizens is very helpful.
And I'm familiar with that type of system, very familiar with that. So I had a tendency to lean that way, but I wanted to be sure that I wanted everybody to know that if it's a commission and it's at City Hall, it's going to be public.
It's public.
Just, I want you to know that. I know everybody's saying commission, but it's going to be it'll be public. Okay?
And that's still.
Yeah.
I want everybody to know that.
Yeah,
All right.
that's-
Yeah.
All right, I just want to try to, I guess, help clarify what I understood from that. It's understandable with the commission, it's going to be public. But before that process, if, let's say, I or someone makes a complaint against a business or an organization, there is a certain need of confidentiality of who is making that complaint right off the bat. In fear of retaliation and things like that. And I know that is somewhat of a protected situation, but it's not always perfect.
Well, and for the business as well,
Yeah.
because you don't know when people are coming to make a complaint if it's going to be a valid complaint. So you don't want to put out there's 20 complaints against this company if it's not. You know what I mean?
Let's take it one at a time here. Go ahead, Kate,
So-
and then Kip, you might want to respond when you get ready.
So it is just to consider the privacy part of it. So there's a need for documentation. There's also a very strong need for privacy is really the point. And I know privacy might not be the most important thing on everybody's agenda, but in my life, privacy is everything. So, I mean, take it however you can. I mean, this is us advising, not making
Right.
the laws, so I do respect that. I just want to put an explanation point by it.
I'm not too familiar with too much privacy.
Well, you know, a lot of attorneys, even other city attorneys in different states, like to have confidential conversations with their clients. In fact, there's rules saying you must maintain confidentiality, but that does not apply for Arkansas city attorneys. We have no right to do that. Everything we do, I'm practicing in a fishbowl. And if somebody wants the help of the government, then you're not going to be able to hide behind a number. You're going to have to be a real person. And the business is not going to be numbered, not the way I'm handling it. I'm going to talk to the business and say, this is what I heard and this is who told me. And we just have to do it in the sunshine in Arkansas. And I will certainly, if someone gets retaliated against, we will do what we can. Of course, we still only have a little fine. We can't do that. There might be other recourse in other statutes, other civil rights statutes for that. Because that might be a violation of your First Amendment rights. If you came and you reported wrongdoing and then you got punished for it, well, it might not be a sexual orientation protection, but it might be a protection of your freedom of speech to come and report under our law about what happened and then you got punished for exercising your freedom of speech. So I just have to tell you, if you're going to use this public system, this governmental system, then you have to do it up front. And everybody needs to know that, and businesses can't hide either. Now, does that mean I'm going to be calling the press every time something like this happens? Absolutely not. I'll be doing a lot of this, I think, over the phone or in person, so I won't be generating a lot of documents. I will have probably a document or two that'll have some basic information on, because people tell me I should keep records. That's probably right. But I will not, I think that, I don't know what will happen with the press, but we have to operate in the sunshine, and that's the law. I like the Freedom of Information Act. I've long thought it was a very good thing for Arkansas. Sometimes it's a pain, but we're going to comply with it.
All right, thank you for the clarity.
Now, we got about 3-4 minutes here, and we've been at this a while tonight, so, who else?
I just got a comment and 2 questions. It's not a lot.
Okay, that will be about, wrap it up then.
Ms. Bartow's problem illustrates exactly why we need education about our options and not just this ordinance. I'm looking at the form here. There's about as much information on it as they ask for you to fill out to get cable or internet. I think this is a great start for a form and a pretty good idea, and the more information we have on the complaints, the better. I did have a question about, there's some apartment management companies that have this thing called a morality clause that affects who rents to them. How does that work in relation to this ordinance?
I guess it depends how it's enforced and what it says. I haven't seen one.
The specific one that I've seen that I've got on a lease agreement is they forbid people that are not married from occupying the same apartment. I wasn't sure if that would be affected by this ordinance or how that works.
That seems to be a discrimination based on familial status.
It does? Okay, thank you so much for clearing that up. I didn't want to look stupid and ask something inappropriate. Thank you.
Okay, so we're about out of time. I want to wrap up just a few things here. I see that everybody seems to be somewhat in favor of a commission. Not everybody maybe, but I'm assuming that. I'll make a call on that. I know that there's some FOI issues I see on concerned about privacy. Is that fair? With some of y'all?
Written documents.
Okay. Records, you want to see records?
Yes.
See that? Okay, and some sort of timeline about how long it's going to take and all this sort of thing, correct?
Procedures.
Yeah, procedures, that's what I have too. I think we clarified the landlords and the background checks. Right?
I think so.
Yeah.
Yes, so we did. You can do those.
Recommendation for more.
It's clear to the ones
For
who aren't
clarity.
lawyers in the room.
Okay.
Recommendation was.
And I've got a few more things, but that gives me plenty to work with. I certainly want to thank you all for your time on this. I probably will not be, I think I have enough to work with what I need to finish up, but I want to thank you for your time in serving and making all the recommendations you have, and I will certainly consider all of it, okay? I'll make a call on that commission probably pretty soon, and we will move forward with this. If the signatures come in, to put it for a vote of the people, then we'll take it to a vote of the people. If it does not, I will have it implemented by September the 20th, correct?
Well, that's its effective date.
That's its effective date, and I will have it ready.
Does that mean you put a stay until, if they?
I believe so, if they get enough signatures.
You'll stay-
Otherwise,
you'll stay on the-
I will implement the ordinance on September the 20th, probably by 5 o'clock.
That's a Saturday.
That's a Saturday, so anyway, that's when it's voted in. All right? Thank you all very much.